Fourth case on this morning's docket, that is case number 106456, State of Kansas v. Terry Ray Hayes.
Good morning, Your Honors. May it please the Court. Lydia Krebs of the Kansas Appellate Defender Office for the appellant, Mr. Hayes. And if I may, Your Honor, I would like to reserve 3 minutes, please, for rebuttal.
3 minutes is granted.
Thank you, Your Honor. Unless the Court would prefer otherwise, I would like to focus on the first issue in the original brief here, which is the instructional issue on voluntary manslaughter, and then submit the remaining issues on the brief. By way of a roadmap, Your Honors, I plan on approaching the issue by first addressing whether the District Court erred in denying the request for the instruction. Second, addressing the state's arguments that the District Court did not err in denying that request. Third, addressing the issue of harmlessness. And then fourth, and finally, asking the Court to reverse Mr. Hayes' conviction for first-degree murder.
I have a question.
Yes.
How was an instruction on voluntary manslaughter factually appropriate in this case?
Right. So we have no dispute over the legal correctness of the issue here because voluntary manslaughter is a lesser included of first-degree murder. So factually, this court in Plummer set forth the test that we apply. And in that case, the court likened the test that the court applies to that the court applies when reviewing for sufficiency of the evidence. So the question is whether, hypothetically, I would argue the question is whether if I were here instead because Mr. Hayes had been convicted of voluntary manslaughter, if I were here asking the court to reverse that conviction for lack of sufficiency of the evidence, would the court reverse? So I think that's the framework here, the test that we're applying in answering the question of whether an instruction would be factually appropriate here.
How can you say that when it's two different standards that are applied? Because in the one, we look at the evidence in the light most favorable to the defendant, and the other, the light most favorable to the state.
Correct. So you'd be viewing the evidence in the light most favorable to the party here requesting reversal, to upholding the verdict or the instruction.
Which is different from the insufficient evidence argument to sustain the conviction.
But there you're still viewing the evidence in the light most favorable to supporting the crime. Even though the parties differ, when you're reviewing sufficiency of the evidence, you're looking at the evidence in the light most favorable to finding evidence that supports that crime. And the same is true here, even though it's the difference between the state and the defendant. Does that answer your question, Your Honor?
Not quite, but proceed.
Well, I'm sorry. Let me see if I can do a better job of explaining it. So when a jury convicts the defendant of the crime of voluntary manslaughter, and I get up on appeal and argue that that conviction has to be reversed for lack of sufficiency of the evidence, this court views the evidence in the light most favorable to upholding a conviction for voluntary manslaughter, i.e., if the jury views the facts in the light most favorable, could it convict of voluntary manslaughter? So yes, that's in favor of the state, but it's in a broader concept, it's in favor of finding evidence of the crime. And then the same is true on the flip side with an instructional error, which is what I'm arguing today, that this court must still view the evidence in the light most favorable to supporting the crime, even though today that happens to be in the light most favorable to the defendant. So yes, the party changes, but the test is still viewed in the light most favorable. Does the evidence support a finding for this crime? And so I would say that the court made that clear in Plummer and also in Haberline set forth that same test. So I think that the court has recognized that the test is similar, if not identical, to that test. So here we have a lot of evidence of premeditation. I wouldn't argue otherwise. And the state has done certainly a great job of pointing out that evidence, but that's not really the question here. The state can't prevail by pointing this court to all of the evidence that weighs against.
Okay, then let's get to the real question here. Where's the evidence of heat of passion, provocation, those kinds of things that I think the trial court went to great lengths to point out did not exist?
Well, I think the trial court only addressed whether there was evidence of sufficient physical provocation and basically said the voluntary manslaughter arises in a typical bar fight. And here we don't have that, so you don't get the instruction. But that totally ignores the fact that sudden quarrel or a physical altercation is only one form of heat of passion. So I think the district court didn't address all the evidence. But here we have all this evidence leading up to premeditation, which I recognize. But then we have Mr. Hayes saying, if you've got a guy with you, don't even stop. So let's say he's got this plan to kill her. When he says don't even stop, and when he motions for them to keep going, I think that's clear evidence that he has abandoned, at least that a rational fact finder could find that's clear evidence that he's abandoned that premeditated intent to kill at that point. Because if he still wants to kill her, why is he telling her to go away? So then we have her showing up with two men, and we have evidence that Mr. Hayes was very sensitive to the idea that she might have been seeing someone else. So he's primed to be upset about this already. We have no evidence that Mr. Hayes is upset before he finds out that she's going to be arriving with Ennis and before the arrival of the car. There's no evidence that he's angry before that. But then as soon as the car arrives, we have evidence that he becomes irate. He's stomping around the driveway and motioning them to keep going, according to Ennis. And then we have evidence that there's an argument that both Mr. Hayes and Tiffany are screaming and yelling at each other, and that then he shoots her. And after shooting her, he says something to the effect of, "How do you like that?" or "Take that." So I think all of that is evidence that he was very upset at that point. Then we also have the evidence that afterwards he goes to Antoinette's house and he tells Antoinette that one of the reasons that he shot Tiffany was that she was rubbing it in his face and had broken his heart. So I would say that given all of that evidence, if I were before the court arguing that Mr. Hayes' conviction for voluntary manslaughter had to be overturned for lack of sufficiency, I would guess that this court would not be very receptive to that argument on appeal. And honestly, I'm not even sure that I would make that argument on appeal, given that evidence. Unless the court would prefer otherwise, I'd like to move on to addressing some of the state's arguments here. So the state starts by addressing State v. Johnson, arguing that the jury heard evidence that tension had been building here between Mr. Hayes and Tiffany for a long time, that Mr. Hayes had purchased a gun, lured her to his residence, and then that several witnesses testified that there was no screaming, yelling, arguing, etc. I would argue that none of these things matter. It doesn't matter how much evidence of premeditation the jury heard. What matters is did it also hear evidence that, when viewed in the light most favorable to Mr. Hayes, would allow a rational fact finder to convict him of voluntary manslaughter. It also doesn't matter that several witnesses testified that there was no yelling, because here we also have evidence and testimony that there was yelling. And just as this court wouldn't reverse a defendant's conviction for lack of sufficient evidence based on some evidence that he didn't commit the crime, it can't affirm a district court's failure to instruct on a crime based on that ground either. So the issue here is really, again, just whether, hypothetically, this court would reverse Mr. Hayes' conviction for voluntary manslaughter if he had convicted of that crime.
But not everyone on this court has stated it that way. I think the statute that speaks to clearly erroneous, the one we always refer to, I can't think of the number, speaks to the court is required to give lesser instructions if the evidence would reasonably support a conviction, or some language, but it says would instead of could. And I think there are some on the court that thinks that means that we weigh whether it's more likely the jury would have found premeditated versus voluntary. So I think you need to address that.
So I think that the language that Your Honor just cited has to do with clearly erroneous review and not where a defendant has requested an instruction. And I think that the statute at issue here uses could and not would. If I'm not mistaken, it says a district court has a duty to instruct on a reasonable or crimes that the jury could reasonably convict of, not would reasonably convict of. Now, later on appeal, if the defense didn't ask for that request, we apply that would the jury's verdict have been different standard. But that's not at issue here because we have a requested voluntary manslaughter instruction. And applying that standard would blur the lines and negate the distinction, the very important procedural distinction that exists when a defendant has asked for that instruction. So you're absolutely right, Your Honor. I should amend my earlier statement that the standard of review that I'm asserting, or the test that this court applies, only applies where a defendant has requested the instruction, not where the defendant has failed to request it, and therefore where the clearly erroneous standard of review would apply. Then we stray from that sufficiency of the evidence test. But in this case, we have a requested instruction, and so that is the language that I would argue would apply here.
Here the jury found premeditation.
Yes.
And how does that affect your analysis in terms of the skip rule, or just that the jury found premeditation? How would they have even gotten to voluntary manslaughter?
So assuming that this was error, the state asserts that the error was harmless based only on the skip rule. The state doesn't make any other argument as far as harmlessness. It relies solely on the skip rule. And while I recognize that this court has held that premeditation and heat of passion are mutually exclusive concepts, that doesn't address the issue here, which is one of temporal concurrence. So, and the state doesn't really address that in its brief, the issue of temporal concurrence in this case specifically. So here, if the jury had gotten an instruction on voluntary manslaughter and heat of passion, defense counsel would have been able to really explain and highlight that you don't just have to find premeditation. You have to find that what actuated the killing is that premeditation. And in depriving him of an instruction on that issue and the ability to argue at closing or even for a supplemental instruction that defense counsel might have requested had the district court properly instructed on voluntary manslaughter, I think that it would be very difficult first under the skip rule to argue that if we disregard it as a strict application and ask just as a route to harmlessness, that there's no reasonable possibility that the jury would have, that one juror might have said, well, I'm not sure if he's guilty of first-degree premeditated murder or voluntary manslaughter. And that's all it takes, is that one juror. Because if there's a reasonable doubt, then you get the instruction that you have to convict of the lesser.
You're saying that even if a person premeditates murdering the victim, if the causation was a sudden quarrel or heat of passion, then they're guilty of voluntary, even though they had thought about it before.
That's what I'm saying and what I believe this court said in Hurt. But I also think that we can take it one step farther. It's one step farther removed in this case because in Hurt, we don't have an intervening event. We don't have a decision on the part of the defendant to abandon his previous plan. So there it was just, I'm acting under this theory of premeditation, but then I see you with my cousin and I'm so angry that I kill you in the heat of passion. There's no dividing line there. It's almost like it morphs or becomes heat of passion. But here we have a dividing line. We have him finding out. So let's say he plans the killing and lures her there with the intent to do that. But when he finds out she's going to be with people or a person, he abandons that plan, obviously, because he says, then don't even stop. So maybe he's going to kill her some other day, but he's not going to kill her there because maybe there are witnesses or because maybe he has this plan for a murder-suicide and he realizes that the presence of other people is going to distract from him getting this confrontation that he wanted with her. So he abandons the plan. He tells her not to come. She comes anyway. Instead of saying, oh, okay, well, she's here anyway, I might as well carry through with my plan. He tells her, don't stop. Just keep going. And then we have her getting out of the car. I mean, he doesn't just walk up and shoot her. We have her getting out of the car and we have this argument occurring. So I would argue that viewing the evidence in the light most favorable to my client, we can find that his plan was thwarted and he decided not to kill her that day, and that removes that even one more step from what this court has already said can reduce first-degree murder to voluntary manslaughter, because here we have him abandoning the plan and then killing her based on heat of passion. I see that I'm out of time, Your Honors. I don't have any further presentation. And
Any more questions? Thank you, counsel.
Thank you, Your Honor.
May it please the court, the state appears by Stephen Obermeyer. With regard to the voluntary manslaughter instruction, I think the cases in the brief, the State versus Johnson and State versus Wade, are pretty clear that you have to have, for a sudden quarrel, some spontaneous, unforeseen, angry altercation, which does not appear to have existed here. You have Tiffany Hayes wanting to pick up her some of her property, and she's bringing people with her so that nothing would happen, hopefully. And the defendant does not just leave the property at the curb for her to pick it up and leave. He meets her outside, tells the kids to stay in the house, don't call the police. He had also stated, what's cheaper, a divorce or a 50-cent bullet? And he goes out and has this encounter. And Judge Davis's findings at page 15 of the blue brief, as far as why a voluntary manslaughter instruction is not appropriate, I think are supported by the evidence that this was a planned execution in his driveway.
Why wouldn't he shoot her in the face when she got out of the truck then? As opposed to, I mean, there was testimony about arguing and yelling, right?
I think the
So
concrete
there is
person.
some testimony of an altercation at the site.
Yes, I think there was testimony of that.
Where did that come from? Testimony about the altercation?
The driver wasn't it? Or the,
I thought it was a witness across the street named Roach who was on his lunch break.
okay. I have another question, and it has to do with legal standard.
Okay.
Your opposing counsel mentioned that this isn't a clearly erroneous case. This is a case where the defense counsel requested the instruction.
Right.
How does that change, if at all, how we evaluate? Plummer was a clearly erroneous case, right?
Right. Plummer was.
I mean, is that the difference between would or could on whether the jury
Well, if
may have found guilt on voluntary manslaughter? I think that was the way your opposing counsel defined the
if
difference.
would or could is a reference to the statute, the 223414, I don't think I'm not sure that applies because there was an objection to it, so it's not the clearly erroneous standard.
Right.
So we have the
So we default back to what the judge's obligation is to give the lesser included, right?
right in the light most favorable to the defendant. And I'd like to save counsel's argument that that's sufficient evidence for voluntary manslaughter for some other brief, because I'd hate to be here arguing that there's sufficient evidence to support a voluntary manslaughter conviction under the facts here. But I think the court can look at all the evidence in the light most favorable to the defendant and decided that was not enough evidence to give a voluntary manslaughter
And
instruction.
our focus is, if I'm understanding you, our focus is on the evidence that would support the lesser?
I think so, yes.
Okay, well, I just want to clarify that overwhelming evidence of premeditation doesn't win the day for you, does it?
Right, there has to be some evidence to support giving the lesser
Okay.
instruction. Yes. And that's why the second degree murder lesser instruction was given, because even though there was overwhelming evidence of premeditation, maybe it was just an intentional killing, and so that lesser was given to the jury. But as far as voluntary manslaughter, the syllabus points from State versus Wade says an orchestrated confrontation or methodically planned encounter is the antithesis of a sudden quarrel, which is what this seems to be. And the fact that Tiffany is in the back seat of this SUV as it pulls up would not make a reasonable person think, oh, she's seeing somebody else. I mean, who's going to have their...
How do you address the troubling fact is that he tells her don't even stop if you have someone with you and waves her on, and she stopped anyway. At least at that time and at that place, it's hard to see that he premeditated killing her there when he's telling her don't stop. Do you understand what I'm saying?
I do, but I think he knew that there had been some text messages, so he knew that she was coming over with somebody else driving her over there.
And in those text messages said don't stop.
And those said that. But
So you really have it both times. You have in advance of her arrival, and then at the time she arrived, he's gesturing to continue on.
Right, but at the same time, you have him telling the kids to stay in the house, don't call the police also.
There may be evidence both ways, but that's why we have a jury, and you've taken that away from the jury. You had the judge make a determination of which crime was most appropriate, and that's not the judge's function.
Right.
To play gatekeeper on which is the most appropriate crime. It's only gatekeeping on what the evidence would support.
Right, and so the fact that he says don't stop does not mean that there was an intense or vehement emotional excitement that would prompt him to do that.
The provocation element of voluntary.
Right.
Yeah.
Wasn't provocation enough? That kind of line.
Right. And I don't think any case.
What was argued to the court for the voluntary manslaughter instruction? It seems like it was just a request. It wasn't articulated as counsel is doing here today.
Right. It might have been one of those for the record, Judge, we're asking for it. I don't recall. It looks like it's at volume 10, page 43. It just says that I just have defense counsel requested it, but I don't think there was much discussion of the facts.
That's what I saw, but I just... Okay.
Correct, because at page 45, the trial court is ruling on the motion, so I don't think there was much argument in support of that. So I still think you...
But it was a legally appropriate lesser included offense.
It is a lesser included offense.
So when we're talking about requested versus not requested, if you request a legally appropriate lesser included offense, does the defendant also have to establish the factual appropriateness?
I think there has to be...
Requesting it?
Yes, I think there has to be evidence to support the giving of that lesser instruction.
But I'm saying, is that burden on the defendant? Or is it a burden on the state to say it's legally appropriate, but here it's not factually? Who's got the burden to establish the factual basis for the trial court?
The language from Plummer says the court should use unlimited review to determine whether the instruction was legally appropriate and determine whether there was sufficient evidence viewed in the light most favorable to the defendant or requesting party that would have supported it. So I don't think the defendant has to, I guess you look at the evidence in the light most favorable to the defendant. The defendant does not have to testify, but a lot of this information Terry Hayes could have testified to if he really felt that he's changed my mind and all this. There's no evidence to support that the giving of the voluntary manslaughter.
He didn't testify at trial, is that correct?
He did not.
Was there any defense offered? I mean, there was a defense through cross-examination of state witnesses, but
Right.
was there any defense presented by the defendant?
I don't recall that there were defense witnesses. He did testify at his sentencing hearing.
Right, he testified the gun jammed. He thought the gun he claimed it was an accident because he thought the gun was jammed.
Right.
That's what he said at sentencing.
Which would also go against voluntary.
No, I understand that, but it's at
manslaughter, but-
sentencing, I don't know.
Yes.
Right.
But still, you have to have evidence of intense, vehement emotional excitement prompting a violent or aggressive action, or a sudden quarrel, spontaneously unforeseen angry altercation. Neither of those exist, even though voluntary manslaughter and involuntary manslaughter are lessers of first-degree murder. You still have to have evidence to support giving that. I think that was really all I had on that issue. I don't think I was going to just leave the skip rule, just rest on the brief argument on that. But I think in State versus Horn, the similar fact. Well, first and second degree instructions are given. Horn does not get a voluntary manslaughter instruction, and the court said that under the skip rule that would have applied. So if you do think that in some
In
world
Horn
that
was the instruction requested?
in Horn,
Yes. You know?
I don't recall. I'm not sure if it was clearly erroneous or not, but the jury certainly had the option of finding second-degree murder in this case and did not do that. I think that was all I had on those issues, unless the court has any other questions.
No further presentation. Any further questions? Thank you, counsel.
Thank you.
If you could start with, where did you develop your facts to support your argument?
Absolutely.
I mean, there was no defense presented in terms of at least his opportunity to present a defense. And you developed your facts from where?
From the testimony of the other witnesses.
And that really was not articulated to the court. Your argument here today is the first time that's really been articulated why a voluntary manslaughter instruction is appropriate based upon your reading of the facts.
It was not as detailed as this, but his defense all along was that this was a breakup fight gone awry and that it was something less than first-degree premeditated murder for that reason. So honestly, even if that's the case, if it wasn't this fully articulated below, I don't know what difference that makes in the court's analysis. The instruction was requested, and that's the only factor that this court has found to be important as far as the standard of review. I wanted to, Your Honor, I misspoke earlier. I looked up the statute at issue here, KSA 223414, and it does say would, not could, but the language is would reasonably justify a conviction, not would reasonably result in a conviction. And then I just looked up justify, if the court will allow me to cite to dictionary.com. The definition is to defend or uphold as warranted, which seems exactly like what this court does in asking whether the evidence would support a jury's verdict. So even though the language of the statute says would and not could, would reasonably justify, i.e. would allow this court to reasonably uphold a verdict for sufficient evidence. So it's not the would-could distinction, as I stated earlier, and I apologize to the court for that. And then I believe someone asked perhaps if the instruction was requested in Hurt. Was that a question?
Horn.
In Horn, I'm sorry. Okay, I didn't check Horn, so I don't have that information for your honors. That was all that I had.
Any further questions? Thank you, counsel.
Thank you, Your Honor.
Both for your arguments this morning. The court will take this matter under advisement.